97%. That is how many separated Australian parents never stand in front of a judge. Not most of them, almost all of them. They work it out across kitchen tables through mediators and awkward phone calls and carefully worded text messages. According to the Australian Institute of Family Studies' National Survey of Separated Parents, only 3% use the courts as their main pathway. So ask yourself the question nobody in Canberra wants to answer. If 97% of families manage without a judge, who exactly is inside the system? The answer is the most desperate, most frightened, most at-risk families in this country. And for them, Australia built a machine that consumes years, life savings, and sometimes lives. Sit with that split for a moment. 97 in every 100 separating couples never need a courtroom to raise their children. 3 in every 100 walk through the court's doors. And those 3 are not there because they are difficult people. The court's own data, which we will get to, shows the overwhelming majority of these cases involve allegations of family violence. These are the families with the most fear, the least money, and the highest stakes. They are exactly the families a civilized country should protect most carefully. Instead, we feed them into a process that takes years, costs everything, and hands down orders that are broken with impunity. Over the next few minutes, I'm going to walk you through that machine, part by broken part. This is All Kids, Lives Matter, Stolen Generation 2.0. I am your host, David Smith, and this is Episode 1, The Machine That Breaks Families. This series exists for one reason. Australian children are being chewed up by a family law system that everyone in power knows is broken. Everything you will hear in this series comes from public data, parliamentary inquiries, the court's own annual reports, peer-reviewed research, and government-commissioned studies. Nothing is invented, nothing is exaggerated. It does not need to be because the documented truth is damning enough. Every fortnight we will take one broken part of this machine and hold it up to the light. If you care about what happens to kids when families fall apart, welcome. Subscribe now because this series is going to name names, follow the money, and demand change. Before we go further, understand where these numbers come from. Not from advocacy groups, not from angry forums or bitter Facebook pages. Every figure in this episode comes from the Federal Circuit and Family Court's own annual reports, the Australian Institute of Family Studies, the Australian Institute of Health and Welfare, the Australian Institute of Criminology, the National Research Organisation for Women's Safety, and the Australian Law Reform Commission. Government bodies, court documents, peer-reviewed journals. Every source is linked in the description, so you can check every single claim yourself. Verified, documented, on the record. Start at the front door. In the last financial year, 101,092 family law applications hit the merged Federal Circuit and Family Court, up 3% on the year before, according to the court's own annual report. That is one new application landing every 5 minutes, day and night, every day of the year. And who is waiting to catch them? 126 judges. That is the entire national bench. 35 in Division 1, 91 in Division 2, backed by 164 registrars. Do the arithmetic. That is more than 800 applications for every single judge, every single year. More than 3 new matters landing on every judge's desk every working day. This is not a staffing problem. This is a system designed to drown. Now look at who those applications are. The court's own 2024 to 25 annual report states that 86% of parenting matters involve allegations that a party has experienced family violence. 86%, up from 83% just 1 year earlier. Let that sink in. This is not a court quietly dividing up furniture and bank accounts. It is a trauma triage ward. And remember, these are the cases that made it past every off-ramp. Mediation, dispute resolution, lawyers' negotiations. What reaches a judge is the concentrated residue of everything those services could not fix. Nearly 9 out of every 10 parenting cases arrive carrying violence allegations, and they land on a bench of 126 judges already buried under a mountain of files. The most dangerous cases in the country, in the most overloaded court in the country. What could possibly go wrong? So follow one family through the doors, a mother, a father, a 6-year-old girl. If their case is complex enough to reach Division 1, and the violent, high-risk ones are, the median time from filing to final judgment is 27 months, straight from the court's own figures. And here is the grim joke. That is the good news. The year before, it was 31. The court calls 27 months an improvement. Now measure it in a child's units. 2 birthdays, 2 Christmases, 3 different school years. For that 6-year-old girl, 27 months is more than a third of her entire life, lived in limbo while the 2 most important people in her world fight through a queue. The court has a clock, children have childhoods. They are not the same thing. Maybe you think a lawyer can speed things up? Lawyers cost hundreds of dollars an hour, so surely legal aid catches the families who cannot pay? No. According to National Legal Aid's own funding analysis, only 8% of Australian households pass the legal aid means test. Meanwhile, 13% of Australians live below the poverty line. Read those 2 numbers together because they are the quiet scandal of this episode. The means test is set so low that you can be officially poor, below the poverty line, and still be too wealthy for a legal aid lawyer, too poor to pay, too rich for help. That is not a safety net. That is a locked door with a means test bolted to it. So mothers and fathers walk into the most important legal fight of their lives completely alone. Now imagine you survive all of it, the 27 months, the fees, the affidavits. At the end, a judge hands you a parenting order, a document with the full authority of the Commonwealth behind it. Here is what the government's own commissioned research found that order is worth. In a national study by the Australian Institute of Family Studies and Australia's national research body for women's safety, 88% of surveyed parents with parenting orders said those orders had been breached. 80% rated the breaches as serious. Nearly 9 in 10 orders broken. And what happens to the parent who reports a breach? They file a contravention application, and go to the back of the same queue that just consumed 2 years of their life. An order nobody enforces is not an order. It is a suggestion. And where, in all of this, are the children themselves? This entire system exists, by law, to serve the best interests of the child. So you would assume judges talk to children. You would be wrong. In a national survey of Australian family law judicial officers, researcher Michelle Fernando found that 86.4% had never once met a child to hear their views. Never. Not one child in an entire judicial career spent deciding children's lives. Across the whole country, judges meeting children happened roughly once or twice a year. Total. The survey found the reasons. Judges worried about a lack of training, about the rules of evidence, about appearing biased. Understandable concerns perhaps, but step back and look at the result. A children's court where the children are invisible. The people with the least power in this system, the kids, are also the people this system refuses to hear. Remember that number the next time someone tells you the court puts children first? Now count the bodies because this machine has an exhaust pipe. According to the Australian Institute of Health and Welfare's National Homicide Monitoring data, a woman is killed by a current or former partner every 11 days in this country. Every 11 days. By the time you watch our next episode, at least one more woman will be dead. And the children, the people this entire system exists to protect, the Australian Institute of Criminology's research on filicide found that roughly 25 children are killed by a parent in Australia every year. That is one child killed by their own mother or father roughly every fortnight. These are not strangers in dark alleys. These are deaths inside families. Exactly the families sitting in that 27-month queue waiting for a court to notice them. And the fathers do not walk away unscathed either. In 2025, the journal Psychological Bulletin published a meta-analysis covering 106 million men. The finding: separated men are 4.8 times more likely to die by suicide than married men. not 48% more likely, 4.8 times. For separated men under 35, the young dads in that court queue, the risk climbs to nearly 9 times higher. Understand what this means. Separation itself is a suicide risk factor of extraordinary size, and we take the most volatile months of a man's life and stretch them across a 27-month legal war. Whatever you think about the gender politics of family law, the research is brutal on every side of it. This machine kills women, children, and men. Here is the part that should make you angriest. The government knows how to fix this. In 2019, the Australian Law Reform Commission delivered Family Law for the Future, the first comprehensive review of the Family Law Act since it was written. 60 recommendations, a complete blueprint from Australia's most senior law reform body. And what happened? Read the government's own response, published in 2021. Of those 60 recommendations, exactly 13 were fully agreed. 19 were, quote, noted, which is Canberra's polite word for shelved. 6 were rejected outright. The rest were agreed only in part or in principle, which in practice usually means never. 60 answers were handed to the government. 47 of them did not get a full yes. The blueprint exists. It is sitting on a shelf, gathering dust, while the queue outside the court grows longer. So, here is what I'm asking you to do, and it takes 5 minutes. First, share this episode with one person who thinks the family court works. Second, go to aph.gov.au, find your federal member of parliament, and ask them one question in writing. Why have 47 of the 60 law reform recommendations to fix family law never received a full yes? Make them answer you on the record. Third, subscribe. Every fortnight, this series takes another broken part of the machine and drags it into the light. The politicians are counting on you scrolling past. Do not. That is the machine. More than 100,000 applications a year, 126 judges, a 27-month queue, and orders broken nearly 9 times out of 10. All of it documented in the government's own reports. Every source from this episode is linked in the description. Read them for yourself, and next fortnight, we follow the money to find out who profits while families burn. The children deserve better. The system must change. See you in 2 weeks.